Biden has appointed a commission to advise him as to whether to pack the Supreme Court. There will be people on the commission who are very good. There will be those who are going to be very radical and want to simply change the courts into institutions that will serve their own ideology and political interests. And I worry because modern day progressives are not like old liberals. They don't support free speech and due process. They oppose free speech and due process. So packing the court might be a lose-lose institutionally and even for libertarian values. You'll hear why on The Dershow. President Biden has just appointed a commission of distinguished American academics and former judges and scholars to assess the future of the Supreme Court and the judicial system in general. Sounds fair enough, but I happen to know a number of the people on the commission. Some of them are former colleagues, some of them are friends. Some are quite good, but some are very, very result-oriented radicals who would instantly transform not only the Supreme Court, but the entire judiciary into a radical set of institutions that would simply promote progressive, by which I mean often today regressive, values that the left is pushing, such as denial of free speech and denial of due process. The commission consists really of two types of people. One, ordinary good scholars who really would like to improve the functioning of the judiciary. And if they examine the judicial branch and see that no changes really are required, they will recommend that. These are honest brokers. But then there are some on the commission that clearly are interested only in pushing their own ideological, partisan, political agenda. Prominent among them is my former colleague, Professor Lawrence Tribe, who never met a constitutional provision that didn't somehow support his own ideology and his own politics. He is not a neutral, objective constitutional scholar. He is a result-oriented constitutional manipulator who uses the Constitution simply to further his own political agenda. I've known him for almost half a century, and I can't remember a single instance where he didn't interpret the Constitution so that it came out to support his own views at the moment. As you probably recall, he was the leading opponent of Robert Bork to be nominated to the Supreme Court because he didn't agree with Bork's judicial philosophy. He was the one who said when President Clinton was president that you can't indict a sitting president because it was President Clinton, who we liked. But then when President Trump became president, suddenly he became woke and realized, oh, my God, I was wrong all this time. You can actually indict a sitting president if his name is Donald Trump. He has already declared in favor of packing the court. He would like to see the court packed with left-wing ideologues. And if he gets his way, the commission will propose Supreme Court packing. I don't think he's going to get his way. I think there are too many good people on the commission that will force a compromise. And here's what I think the compromise will be. There will be court packing, but it will not be packing of the United States Supreme Court. That's too hot a potato. And too many people who are credible in the Democratic Party oppose Supreme Court packing. They remember when Franklin Roosevelt tried to do it in the 1930s. In fact, President Biden, when he was a senator, described that as boneheaded. And it was boneheaded, and it was wrong. And it would simply lead to a cycle whereby every time a new administration came into power and they had control of the Senate, they would pack the court with more of their own, and we'd move from 9 to 12 to 14 to 18 to 25 to 35 ad infinitum, and it would never end, and it would destroy the credibility of the Supreme Court. That's happened in other parts of the world, and so far we've prevented from happening in the United States. But there's a movement in that direction. Look, part of the fault lies with the Republicans as well. They stole a seat from President Barack Obama when Merrick Garland was appointed, eminently well qualified, now the Attorney General of the United States, centrist, Democrat, but centrist. The Republicans refused him even a hearing, and I think that was wrong. I think that was unconstitutional. And it began a cycle. Actually, the cycle did begin with the Bork failure to confirm, but it continued a cycle. And so there's fault on all sides. But the American public benefits enormously by keeping the Supreme Court a nonpartisan judicial institution that serves as a check and balance on the partisan branches of government, the executive and the legislative branches, which are elected. The Supreme Court, the judiciary are appointed for life, which leads us to another suggestion that some have made, and that is, why should we appoint Supreme Court justice for life? How about 20-year terms? For me, that would make some sense, but it has to be only prospectively. You can't now say to somebody who's sitting on the Supreme Court that they have to leave after 20 years. That would mean a whole bunch of them would now have to leave today. And you can be sure Tribe is going to suggest that because he'd like to see turnover on the Supreme Court so that his people can be put in the seats that are now occupied either by moderate liberals or by conservatives, which leads me also to what Chuck Schumer has proposed. And it's just outrageous to hear the majority leader of the United States Senate calling for Justice Stephen Breyer, who I've known for half a century, again, a colleague of mine, along with Professor Tribe, a moderate liberal, urging him to resign immediately so that the president can appoint a black woman to the Supreme Court, namely an ideological ally of Schumer and Tribe and others on the left. I hope Steve Breyer won't submit to that kind of pressure. That would just, as he said, politicize the court even further. You should not be timing resignations for who your successor is going to be. Justice Ginsburg was criticized in her death. The body was still cold when radicals were complaining that she didn't resign on time and that her place was filled by a conservative Republican. Look, I'm a liberal Democrat. I'd like to see more liberals on the Supreme Court, not the kind of liberals Tribe wants on the court. I want the kind of liberals that now serve on the Supreme Court, Breyer and Kagan and Sotomayor, who support free speech and who support due process. My great fear is that the vacancies will be filled not by liberals or libertarians, but by radical progressives who are really regressives. That is, people who don't support freedom of speech, who don't support due process, who are result-oriented, who think that, why do we need due process and free speech? We know the truth with a capital T. We know the truth. We know America is a racist society from top to bottom. We know that it's incurably wrong and bad. We know that police officers are all wrong and don't need to have due process or trials. Just punish them. We know all these things. They're so true with a capital T. Why do we need dissenting opinions? Why do we need due process? They're just cumbersome devices imposed on us by patriarchal, capitalist, imperialist, colonialist mentality. That's the kind of attitude we're hearing from the left today. And I worry very much that if the court packers get their way, they will see the court dominated and the courts, lower courts, dominated not by liberals and libertarians, but by radical leftists who show no appreciation for the essence of our Constitution, which is free speech and due process, dissent and process. It was Felix Frankfurter who said the history of liberty, for the most part, has been a history of procedure and process and due process. But radicals are impatient. They don't want due process. They want results, and they want it today. They want it yesterday. And they want to see the court become just another super legislature. Look, we see that on both sides. We see judicial activism on the right. We see it on the left. We see people on the right wanting to get their way. We see people on the left wanting to get their way. The Supreme Court and the lower courts are supposed to be anchors. They're supposed to be institutions that check and balance majority impulses. Remember, America was never supposed to be just a democracy. It was always supposed to be a republic with a system of checks and balances. The greatness of our Constitution is not so much in its substantive content, but in its structure, in its separation of powers, in its checks and balances, in its ability of the judiciary to serve as a check on the excesses of democracy. And it's never been more important than now, because now we see the hard left moving toward limiting free speech and limiting due process, and the courts are essential to making sure that that doesn't happen. So I think the end result of this commission probably will not be packing up the Supreme Court. Tribe will support it. A number of the other radicals on the commission will support it. It'll give the president cover if he either wants to do it or says, look, I've rejected the most extreme views of my commission. But let me tell you, there will be court packing. And the court packing will occur at the lower level. The commission will recommend, and even if they don't, the president and the Senate and the House will support a massive increase in the number of judges, both appellate court judges and district court judges. And the purpose of that is not to ease court congestion or to make the courts more efficient. The purpose is to appoint more Democrats and more people of the left to the lower court positions. And remember, 95 or more % of decisions are rendered by the lower courts, by the courts of appeals, which are the final courts for the vast majority of cases, and the federal district courts and the magistrate judge courts. And if they can be loaded during the next 4 years or 8 years with people on the left, it will have almost as much impact as if the Supreme Court were packed, and will do it with less visibility. People won't even notice if 100 more judges are appointed, or 100 more appellate court judges are appointed, and 200 more district court judges are appointed. No one will notice. The focus will be on the Supreme Court. So watch carefully, listen carefully to what this commission recommends. So I suspect it will recommend perhaps term limits. I could support term limits if it's prospective. It probably would require a constitutional amendment. Remember, when the framers said life tenure, or tenure during good behavior, which means life tenure, the average life expectancy was in the 50s. So if you were appointed in the mid-30s, you might serve 20 years. But today you have justices serving 35 years. That's too much. Only the Pope, maybe in kings, should serve during lifetime. In a democracy, there should be no lifetime appointments. And so I would support, myself, term limits. I would not support mandatory retirement, because mandatory retirement, say 70, would incentivize presidents to appoint younger and younger and younger judges and justices. If you're going to have to retire at 70, why not get appointed at 35 so you can serve 35 years? It would undercut term limits if you had mandatory retirement. So term limits are much better. 20 years is good. 18 would be good. I wouldn't oppose 15. I think anything above 20 is too much. You'd probably need to amend the Constitution. And if you didn't amend the Constitution, you certainly would need to make it only prospective. But Tribe is going to say, no, don't make it prospective, because if you make it only prospective, that means term limits applies only to the people that we, the Democrats, are now going to appoint. And that's not what result-oriented people like Tribe have in mind. They want to see immediate changes in the courts so that their progressive ideology is pushed by the judiciary. So Tribe's not going to support institutional changes that don't have immediate benefits. Certainly you won't support it if they have disadvantages, and term limits applied prospectively would have immediate disadvantages for the Democratic Party, because it would mean that all the justices and the judges who are appointed over the next 3.5 years, maybe the next 7.5 years, would be subject to term limits. But the older justices, the Alitos and the Thomases and others, would not be subject to term limits. And that's the last thing result-oriented academics want. So keep your eye on this commission. It will disappear for a while. We won't hear much from it. They have 180 days. That's a long time. And my prediction is there will be a split conclusion on court packing. Majority will be opposed to Supreme Court court packing. Majority will favor some form of term limit, but not favor, hopefully, mandatory retirement age, which would be a terrible mistake, I think. We will see massive court packing in the lower courts, and that will continue when the Republicans become president and take over the Senate. They will probably pack the lower courts with more and more and more judges. But hopefully the Supreme Court will remain immune, not because principles will prevail, but because I think wise heads would realize that if you add 4 justices now under the Democrats, they're going to add 6 when the Republicans come to power, and it will just continue down a cycle into a rabbit hole where the Supreme Court will be so large it will lose its institutional credibility. So I'm interested in your views. What do you think of court packing? What do you think of this commission? What do you think of President Biden's idea of giving a hard new look at the judiciary? Call me. Let me have your views. I'm interested. This is an issue that affects all of us, and I want to hear what you have to say on the Dershow. Now, my favorite part of the Dershow, the wits. Your callers, first call.
Hello, Professor Dershowitz. This is Paul from Westminster, California. I have 2 questions for you. First question, do you have some sort of special status with the Nobel Committee that they take your nomination of Kushner seriously? Second question, what if some BLM-type person calls a press conference and announces that if Chauvin is acquitted, he will publish the name, address, and phone number of every jury member? Is he using protected speech? I look forward to your answer, Professor Dershowitz.
Great questions. Thank you very much. I do have a special status with the Nobel Committee. I'm a professor emeritus of public law, and any professor emeritus of public law at a major university gets to make nominations. I have made, I think, 4 nominations over the years. I nominated Elie Wiesel, who won the Peace Prize. I nominated Bernie Lown, who won the Nobel Peace Prize, and I've nominated Erwin Cutler, who has not yet won the Nobel Peace Prize. And I did nominate 4 people, including Jared Kushner, for the work they did on the Abraham Accords, which I think is the most significant development toward peace in the Middle East in a generation. So I hope they will take it seriously. If anybody threatened to disclose the names of the jurors, they would be in contempt of court, and that disclosure would not be protected by the First Amendment.
Professor Dershowitz, my name is Jay. Questions about what Dr. Tobin said would be lethal with their knee on someone's neck. Can they duplicate what Dr. Tobin stated, that on a normal, healthy person, that person would die even without drugs by having their knee placed on the victim's neck? Can we duplicate that using Officer Chauvin as the victim and have someone the size of Floyd and duplicate the same mechanism and just see if the police officer lives? I think he will, without having any drugs or any heart condition. This might sound crazy, but it might show that the officer didn't think what he was doing was going to kill anybody, especially if he was willing to undergo the same maneuver as he did for the victim Floyd. It might sound bizarre, but I'd appreciate your opinion. Thank you.
I don't think we permit in this country experiments on human beings that might prove to be lethal. Look, I think Dr. Tobin was wrong. I think he overstated his conclusions. He was much too certain. It turns out that George Floyd has an enlarged heart. And I think if you ask experts, and I've now asked a bunch of them, they will all tell you that an enlarged heart of the kind that George Floyd had requires more oxygen to keep pumping. And so that you can't say that the enlarged heart had no impact on the timing of death or the cause of death. The same thing is true of massive drug use and very high blood pressure. The human body is just too sensitive and too specific, individual to individual, for an expert to make the kind of categorical statement he made. I think that he will be devastated by the defense case when you hear expert after expert coming in and saying, look, we don't know for sure, but certainly the heart condition, the high blood pressure, and the drug use may well have contributed to the death. We probably can't say for certain that he would have lived through 9 minutes, but we can't say for certain he wouldn't have. And remember, the government, the state, has the burden of proving beyond a reasonable doubt. So I think Dr. Tobin was much too certain of his views, and I think in the end was not correct when he said that the heart condition, the blood pressure, and the drugs weren't even contributing factors, that the same result would have ensued, that is, death within whatever, 6 minutes. He said death occurred at about the 6-minute mark or something thereabouts, no matter what the health of the person would be. I think that's just wrong.
My name is Don. I'm calling you from Gainesville, Florida. Professor Dershowitz, I'd like to say I'm a fan, and I am kind of. I've always respected you until the show that you just recently recorded. You were asked a question on the phone about why do you feel the Georgia law is unfair and repressive. And your answer just lacked total substance. You said that, I guess you gave two reasons. One was they were requesting ID, and sort of other statement about absentee ballots. Professor Dershowitz, what is wrong with presenting an ID when you vote? You've heard this argument before, but it almost sounds racist, Professor Dershowitz, for you to say that minorities, specifically African Americans and Latinos, aren't capable of having identification. It makes no sense to me whatsoever. So if that's your argument, it just doesn't hold water. Thank you.
No, that's not my argument. Of course, minorities are capable of having IDs. Many liberals want everybody to have IDs that show they've been vaccinated. And so you see hypocrisy on both sides. I have no doubt that the Georgia statute was motivated by a desire to suppress Democratic voters and to increase the number of Republican voters. That's why I would have voted against it. I don't believe in voting for laws that are motivated by a desire to suppress any kind of voting. I think it should be much easier to vote. I think the goal should be to get everybody out voting and to minimize the number of fraudulent ballots. I don't think the Georgia statute meets that criteria. I also don't think it's substantially discriminatory enough to warrant the kinds of protests that we've seen. I think it's politics as usual. I'm opposed to it. I would have voted against it, largely because I think it was motivated by a desire to suppress voting. And I think politicians know better than anybody whether or not statutes are going to have that kind of an impact. The New York Times did an analysis saying the politicians were wrong, that it wouldn't have a major impact. But on balance, I would have voted against it because I think the motivation behind it was to help one party and hurt the other party, and that's not a proper function of legislation.
Hello, Professor Dershowitz. Enjoying your show. I have a question about this, the private right of companies like YouTube, Twitter, Facebook, to censor or deny people to put their content on there. And I remembered that the Supreme Court, the U.S. Supreme Court, ruled a long time ago that you can petition within a private mall. And I looked that up. The case was called Pruneyard Shopping Center versus Robbins. And they upheld a California State Supreme Court law allowing the protesters to gather signatures. And they said that it was a Fifth Amendment, 14th Amendment case, and also whether it was protecting free rights under the First and 14th Amendment. A few years later, in the 90s, the New Jersey Supreme Court also ruled that petitioners inside private property, a mall, again, can gather signatures. Can't those principles be applied? The public square now is virtual. It's online. So I look forward to hearing from you whether you think that there could be either a state and or federal case based on these principles made. Thank you. Oh, and my name is Cesar Darius.
Thanks, Cesar. It's a great question. And I think you have a point. There are those cases that say that private property sometimes is subject to the First Amendment. The mall cases you mentioned, there's a case called Marsh versus Alabama, where a company set up a company town and prohibited speech, and the Supreme Court said, no, you couldn't do that. Obviously, cases are all different, and the internet is a little different than the mall, but you're right, it's the public square. And I think arguments can be made, but then do you apply that to the New York Times? And the Supreme Court has held in the Miami Herald case that you cannot compel a newspaper to print material it doesn't want to print. In that case, it was a letter correcting, if I remember correctly, a falsehood in the newspaper, but the Supreme Court said you couldn't make them print it. So I think it's a subject that's very much open to debate, and I think we will see that argument being made. Justice Thomas has already made an argument akin to that. He hasn't called it a public space or a public forum, but he talked about it as a common carrier or a public accommodation. And so I think the next decade, we will see a lot of challenges to the internet, private companies on the internet, absolutely prohibiting and censoring entire categories of people.
Hello, Alan. This is Elliot Reif. I live in Bucks County, Pennsylvania, although originally a Yankee fan from the Bronx. I really enjoy your show, and especially listening to your normally well-reasoned arguments when I disagree with you, because it's really good to hear the other side's best spokesperson. However, I must take strong issue with your comments today about Justice Thomas's opinion, because I think you omitted a singularly important point, which is that these internet platforms pretend to be operating under Section 230, which provides them with umbrella protection from the government. So if you want to take advantage of the umbrella protection of the government, you have an obligation to foster the values of the American government, which are free speech, unless it violates the law, incites to violence, whatever, or one of the other very narrow exceptions to the First Amendment. I very much look forward to hearing what you have to say.
Despite you being a Yankee fan, you make a very, very, very good point. I'm a Red Sox fan. I used to be a Brooklyn Dodger fan when I lived in Brooklyn. But your point's a good one. I don't think that social media can both take advantage of Section 230 and then start censoring people. 230 is premised on the assumption that the platforms are simply platforms. They don't engage in censorship. But the very presence of 230 doesn't necessarily mean that you can tell social media platforms what they can say and what they can't say. What it may show is that they can't take advantage of 230 if they do censor, and I think that's right. And I think there's legislation now under consideration that would eliminate Section 230 exemptions from any social media that engaged in selective censorship. And that, to me, would make a lot of sense. So, great call. Again, wonderful, wonderful calls today, really challenging a lot of my views. And those are the best calls, the ones that challenge what I have to say. So please keep them coming. Please subscribe, YouTube, Rumble, any of the other platforms. We need subscribers to stay on the air. And please tell your friends, and please keep the calls coming. That's the most important thing. And don't hesitate to be critical of what I've had to say on the show. I make my points to bring out your points and to get criticisms from you. And today we got lots of good criticisms, and I had an opportunity to respond. So keep them coming to the Dershow.
An important part of the Dershow is your voice, your questions, your comments. Please call 24/7. The number is 216-710-0050. Keep your comments short and to the point. Again, the number for you to call 24/7 is 216-710-0050. Hard questions, criticisms, everything's fine. Just keep your questions short, and I'll answer them all on the Dershow.